The USDA inspector tried to seize my farm pond 3 times before she figured out I was a retired soil conservationist. First time, she mailed a certified letter claiming navigable waters jurisdiction under the Clean Water Act. Second time, she convinced the county to slap a red tag stop work order on my irrigation pump, alleging unpermitted discharge. Third time, she rolled up at dawn with a D6 Caterpillar dozer, a flatbed of riprap, and a crew wearing matching orange vests, ready to dredge a public fishing access channel straight through my best alfalfa stand. That's when I called the sheriff. My name is Harlan Whitaker. I'm 64, widowed, and I spent 38 years with the Natural Resources Conservation Service, NRCS, mapping watersheds, designing terraces, and writing conservation plans for farmers who actually wanted the help. I know exactly where one man's dirt ends and the federal government's imagination begins. Which is why when Inspector Carla Mendoza told me my 3-acre pond was now a waters of the United States, I didn't argue. I just smiled, nodded, and started building a case. 6 months later, I was standing on the dam berm I'd surveyed myself in 1998. Boots planted in the same clay I'd keyed in with a nuclear densometer, watching that yellow dozer grind to a halt. The operator climbed down, holding the court order I'd handed him. He read it twice, scratched his hard hat, eyed the heavy chain I'd stretched across the service road, and climbed back into the cab. The big diesel coughed, reversed, and disappeared over the hill in a cloud of caliche dust. 200 yards away, Carla Mendoza's face was the color of fresh blood on white paper. What she didn't know, what none of them knew, was that I had every email she'd ever sent, every trespassing boot print on camera, every false claim documented in triplicate and backed up on 3 separate drives. And I'd been waiting 6 months to use it all. But she didn't start with threats. She started with a smile and a clipboard. It was March 12, 2024. I'd been living full-time on the ranch for 8 months when Carla Mendoza knocked on my screen door. She wore the standard khaki uniform, USDA badge polished to a mirror, and carried a metal clipboard like it was a riot shield. "Morning, Mr. Whitaker," she said, flashing a smile that never reached her eyes. "Regional Water Quality Initiative. Mind if I take a quick look at your pond?" I invited her onto the porch. We sat in cedar rockers overlooking the water. Spring-fed, 22 feet deep in the center, stocked with largemouth bass since 1999. She launched into the pitch, how the agency was partnering with landowners to improve public resources, how farm ponds were critical nodes in the watershed, how equity demanded access for underserved communities. Then she got to the point. "We've always had access to ponds in this watershed," she said, gesturing toward my dam. "Previous owners were real cooperative about letting folks fish and recreate. I'm sure you'll want to continue the tradition." I didn't know federal overreach politics back then. I'd bought the quarter section in 1987 for $78,000. Prime bottomland, 110 acres tillable, the rest pasture and cedar breaks. The pond was dug in 1938 under a WPA program. My deed included the water rights decree, the spillway easement, the whole enchilada. I'd rebuilt the dam myself in 1998, compacted clay core, 3:1 slopes, emergency spillway engineered to NRCS specification 378. Paid for every yard of dirt, every load of riprap, every hour of dozer time. When my wife Ellen died in 2020, I moved here permanently. Built a small ICF house, planted alfalfa, ran 40 head of Angus. I wanted quiet mornings with coffee, watching the sun rise over the cottonwoods, maybe wet a line now and then. I wasn't looking for a fight. So when Carla asked for routine water quality monitoring, I said sure. "Take your samples," I told her. "Just stay on the service road. No vehicles on the dam. Respect the gates." She thanked me like I'd handed her the deed. What I didn't realize was that Carla wasn't asking for cooperation. She was confirming what she already believed. My pond belonged to the public. See, Carla Mendoza wasn't just a field inspector. She was the regional lead for the USDA's Equity in Access program, new initiative, big ARPA funding, lots of press releases. And according to her quarterly reports, every farm pond over 1 acre in the county was a community water resource eligible for public fishing, boating, and environmental education. I found that out later. For the first 7 months, it worked fine. She'd show up once a month, dip her little vials, snap photos with a tablet, leave by noon. I'd wave from the tractor, she'd wave back, no issues. Then on October 18, 2024, I stopped by the County USDA Service Center to renew my EQIP contract, cost share for a new center pivot. That's when I saw the poster on the bulletin board. Full color, glossy, Clear Creek Watershed Public Access Project, Phase 1. The rendering showed a gravel parking lot for 40 vehicles, a concrete boat ramp with ADA curb cuts, and a fishing pier with solar lights jutting 60 feet into my pond. At the bottom, estimated cost $212,000. Funded by American Rescue Plan Act and Special Watershed Assessment. I stared at that rendering for a full minute. The ramp was drawn right through my north field, tearing out 80 feet of established alfalfa. I walked back to the ranch, pulled my 1998 survey from the fire safe, and traced the pond boundary with my finger. No question. That ramp would be built on land I owned, land I paid taxes on, land the feds had zero recorded claim to. The next morning I found a laminated notice zippily zip-tied to my gate. Notice of Intent, Public Access Improvement. Clear Creek USDA will begin Phase 1 construction on November 15, 2024. This project is funded by ARPA and approved by the Regional Watershed Council. For questions, contact Inspector Carla Mendoza. Called her. She answered on the first ring. Harlan, did you see the notice? Exciting, right? Carla, I said, keeping my voice level. Did anyone from USDA ask my permission to build on my pond? There was a pause, then a short, confused laugh. Permission? Harlan, it's a public water. We don't need permission. No, I said. It's not. My deed says otherwise. Well, she said, and I could hear the smile fading. We've been sampling it for years. Everyone knows it's part of the watershed plan. Show me the easement, I said. Another pause, longer this time. The what? The recorded easement. The legal document giving USDA rights to my pond. I don't think we have anything like that, she said slowly. But it's always been. If you don't have an easement, Carla, you've been trespassing for 7 months. And if you build that ramp, I'll have it torn out and bill the agency for damages. The line went quiet. Then she said in a voice I hadn't heard before, cold and clipped, "We'll proceed as planned, Mr. Whitaker. This is for the good of the community." And she hung up. That night I pulled every document I had, the original survey, the water rights decree, the property tax receipts. I read the 2018 Clear Creek Watershed Management Plan online. Mentioned public access in aspirational language, but no legal description, no metes and bounds, no notarized agreement with me. It was all smoke. And Carla Mendoza, USDA inspector and project lead, had been promising lake-style fishing for underserved youth to county commissioners for 2 years. I sat back in my chair, looked out at the dark water, and picked up the phone. Called an old NRCS colleague now in private practice, water law attorney Lena Torres. Lena, I said when she answered, I need your help, and I think you're gonna enjoy this. Lena Torres had spent 30 years fighting the Corps of Engineers over wetlands delineations. When I laid out the situation, she was quiet for a moment. Then she laughed so hard she snorted. Harlan, you have what we call a slam dunk. But feds don't lose gracefully. They have money, lawyers, and PR. Prepare for it to get ugly. How ugly? I asked. Fines, liens, media smears. They'll make your life miserable for as long as they can. I looked out at the pond. My pond, owned by my family since 1919. What do I need to do? Document everything, she said. Every interaction, every trespass, every threat. Get it in writing, get it on camera, build a case so airtight they can't wiggle out. Then we hit them so hard they never try this again. I spent the next 3 days preparing. Ordered a Reolink trail camera from Amazon. 4K, solar-powered, cellular upload, motion-activated with night vision and timestamp. Mounted it on a cedar post at the entrance to the service road. angled to capture license plates and faces. Then I printed bright orange property line markers, USDA proof vinyl, and staked them every 25 feet around the entire pond perimeter. On October 22nd, I sent an email to the entire regional USDA chain of command, CCing the state conservationist. Subject line: Objection to public access project on private property. Body: I do not consent to construction on my property. The pond and surrounding land are private property as evidenced by the attached survey, deed, water rights decree, and tax records. Any entry onto this property without my explicit written permission constitutes trespass under state law. I expect all construction plans to be halted immediately. I attached my 1998 survey, my 1987 deed, the 1938 water rights decree, and property tax receipts showing I'd paid 100% of the taxes on that parcel since purchase. Sent it certified mail with return receipt requested. Carla's reply came back in 41 minutes. Harlan, you're being obstructive. 14,000 watershed residents depend on equitable recreational access. We've already awarded the construction contract and collected the special assessment from landowners. We will proceed as planned on November 15th. If you have concerns, you're welcome to attend the November 5th stakeholder meeting. Obstructive. That word stuck with me. I'd mapped every contour on this place with a transit level and a 100-foot tape. I'd written the conservation plan that kept this soil in place for 3 decades. And now I was obstructive for not letting them bulldoze my field. I forwarded Carla's email to Lena. She called me 10 minutes later. Harlan, this is gold. She just admitted in writing that they're proceeding without your permission. That's knowing and willful trespass. What's my next move? We file for a temporary restraining order. Stop the construction before it starts. And in the meantime, you keep that camera rolling. I want footage of every single person who steps foot on your property between now and November 15th. I hung up and looked at the calendar. October 22nd. I had 24 days until the dozer showed up. 24 days to build a case that would end this before it started. I opened my laptop and created a spreadsheet. Columns: date, time, actor, description, evidence file. Then I waited. I didn't have to wait long. The trail camera started recording on October 25th. By Halloween, it had captured 31 separate incidents. School groups on environmental field trips with USDA badges. Kayakers launching inflatables from my bank. A church youth group holding a picnic on my dam. I didn't confront anyone. I just logged every entry into my spreadsheet and saved the footage. On November 3rd, I ran into my neighbor Ray Delgado at the mailbox. Ray ran 300 head on the next section, always waved when he saw me. This time he looked around like he was checking for drones, then leaned in close. Harlan, I heard about the pond situation. Carla's telling the commissioners you're holding the watershed hostage. Watch your back. Thanks, Ray. He hesitated. Look, I don't want to get involved, but she pushed that contract through suspiciously fast. No competitive bids. Just said her brother-in-law's company could do it cost-effective. Delgado Earthworks. They do a lot of federal work. I filed that away. Delgado Earthworks. Federal work. I called Lena that night. The USDA awarded a $212,000 contract without competitive bidding. Does that matter? Depends, she said. If there's a conflict of interest or kickback, it could invalidate the contract. But that's a separate issue. Right now, we focus on the trespass. One thing at a time. Got it. Anything else? Yes, she said. Be prepared for them to claim NAV 3364 jurisdiction under the Clean Water Act. They'll argue your pond is a water of the United States because it's connected to a tributary. But they need a formal jurisdictional determination, and they don't have one. I looked at my trail camera footage. 31 incidents in 9 days. If this kept up, by November 15th, I'd have over 100 documented trespasses. Let them argue jurisdiction. I had timestamps. November 15th arrived cold and clear. I woke at 5:30, made coffee, and walked down to the service road. The chain was already in my truck bed, 20 feet of 3/8 inch hardened steel, Navy-grade padlock, the kind that laughs at bolt cutters. At 6:50 I heard the rumble of diesel engines coming up the county road. I called Deputy Maria Ortiz. Maria and I had judged 4-H livestock shows together. She was former Army, early 40s, the kind of deputy who read the statutes instead of guessing. Maria, it's Harlan Whitaker out on Section 19. I've got a construction crew about to trespass on my property. I have a restraining order from the court. Can you meet me here? On my way. The D6 dozer came around the bend at 7:05. Big yellow cat, treads clanking, operator in the cab scrolling on his phone. Behind him, a Delgado Earthworks pickup with 2 workers in the bed. The dozer stopped at the property line where my orange markers were staked. The operator climbed down, lit a cigarette, and looked around like he was trying to figure out if he was in the right place. I walked over. Morning. Can I help you? Yeah. We're supposed to start a public access ramp down there. He pointed toward the pond. Do you have permission from the property owner? He looked confused. USDA hired us. I'm the property owner, I said. And I didn't give permission. His face changed. Look, man, I don't want trouble. I just go where my boss tells me. I understand. Here. I handed him 3 documents. This is a certified survey showing I own this property. This is a copy of my deed and water rights decree. And this is a temporary restraining order from the county court issued yesterday prohibiting any construction on this parcel without my written consent. If you proceed, you're in violation of a court order. He took the papers, read the first page of the TRO, and his shoulders sagged. He pulled out his phone and called someone. I could hear the conversation. Yeah, it's me. We got a problem. The landowner's here with a court order. No, he's serious. There's a sheriff's deputy pulling up right now. I don't know, man. You figure it out. I'm not catching a contempt charge for a fishing pier. Maria's cruiser rolled to a stop behind the dozer. She got out, adjusted her duty belt, and walked over. Gentlemen, what's the situation? The operator showed her the TRO. Maria read it, nodded, and looked at the crew. You're free to leave. If you proceed onto this property, you'll be trespassing, and I'll have to arrest you. The operator didn't need to be told twice. He climbed into the cab, fired up the engine, and backed the dozer up the hill. The pickup followed. The whole thing took 8 minutes. Then Carla's Tahoe came screeching down the road. She got out before the car stopped rolling. Her face red, her voice shaking. What the hell do you think you're doing? Protecting my property, I said. You can't do this. That ramp is funded. We have 14,000 residents who... Show me the easement, Carla. She stopped, blinked. What? Show me the recorded easement that gives USDA legal access to my pond. We don't need an easement. It's navigable waters. That's called trespassing, Maria said quietly. Carla turned to her. Deputy, this is a federal matter. Ma'am, Maria said. He has a restraining order. If you proceed with construction, it's contempt of court. That's criminal. I handed her a copy of the TRO. You're served. There's a hearing in 14 days. Bring your lawyer. Her hand trembled as she took the paper. Then she turned and walked back to her car without another word. After she left, I pulled the chain out of my truck, stretched it across the service road, and locked it. The padlock made a satisfying click. I mounted a sign. Private property, no trespassing, violators prosecuted. Maria watched me work. You know this is just the beginning, right? I know. They're going to make your life hell. Let them try. I took a photo of the lock chain with my phone. Timestamp, November 15th, 2024, 7:42 a.m. Then I walked back to the house and added it to my evidence folder. The padlock stayed locked for exactly 3 hours and 42 minutes. At 11:27 a.m., the trail camera caught 3 people walking down the service road. Carla Mendoza, a man I didn't recognize wearing a suit and a USDA lanyard, and County Commissioner Roy Delgado, Carla's brother-in-law. They stopped at the chain. Carla pointed at the padlock. The man in the suit pulled bolt cutters from a briefcase. The camera captured everything. Audio picked up Carla saying, "Just cut it. He can't stop the federal government. The man positioned the bolt cutters on the lock. He squeezed. The handles bent. The lock didn't. He tried again, putting his full weight into it. Nothing. What the hell kind of lock is this? He muttered. Military grade, I said from behind them. All three jumped. I'd walked down through the cedar brake, staying off the road. That's a Navy pack lock, hardened steel shackle. You'd need a plasma cutter to get through it. Or, my permission. Carla's face went white, then red. This is obstruction of federal duty. No, I said. It's trespass and attempted destruction of property. Leave before I call Deputy Ortiz again. The man in the suit stepped forward. Mr. Whitaker, I'm Regional Director Paul Hanley. We represent. I know who you are. You can send any correspondence to my attorney, Lena Torres. I handed him her card. Now get off my property. They left, but I kept the camera footage. Added it to the spreadsheet. November 15th, 2024, 11:27 a.m., attempted destruction of property. 3 witnesses, audio and video evidence. The USDA held an emergency stakeholder meeting 2 days later. Number 48-hour public notice, which violated the state's Open Meetings Act. A neighbor texted me a photo of the agenda. Emergency session legal action against Harlan Whitaker. The council voted 7-2 to levy a $1,000 per day fine against me for blocking public access to waters of the United States. They also voted to authorize the Office of General Counsel to file a counter-injunction. They sent a mass email to all 14,000 watershed residents. Subject: Critical Watershed Update. Body: due to the actions of one obstructive landowner, the public access project has been delayed. Harlan Whitaker has illegally blocked access to a community water resource, harming recreational equity and delaying environmental education for underserved youth. The council is taking legal action to protect your rights. I forwarded it to Lena. She called me 30 seconds later, laughing. Harlan, they just slandered you in writing to 14,000 witnesses. This is malpractice-level stupidity. Is that good for us? It's Christmas morning for a litigation attorney. 2 days later, an 8-page demand letter arrived from USDA Office of General Counsel. Certified mail, signed receipt. The letter claimed navigable waters jurisdiction under the Clean Water Act Section 404. It demanded I remove the chain, cease all interference with USDA activities, and pay damages of $180,000 for delayed equity and environmental justice. It was CC'd to every county commissioner and emailed to the watershed list. My phone started ringing that night. Some calls were supportive. Most weren't. One man, voice shaking with rage, told me I was denying children clean water. A woman said I should be ashamed for keeping underserved communities from fishing. Someone left a voicemail that just said, I hope your cattle die. I saved every message, added them to the evidence file. Harassment, threats, November 19th through December 5th. Then the vandalism started. November 25th, someone spray-painted Greedy Farmer across my barn in 6-foot red letters. I filed a police report. November 27th, all 4 tires on my pivot were slashed. Another report. November 29th, someone dumped a barrel of used motor oil into my irrigation ditch. The smell was incredible. I took photos, filed a 3rd report, and cleaned it up with absorbent pads. The online posts were worse. Anonymous accounts with names like Watershed Equity Now and Public Access Advocate posting things like selfish rancher blocking our pond. Disgusting. Who does Harlan Whitaker think he is? If you see him in town, let him know. I stopped going to the co-op, started driving 40 minutes to the next county for supplies. Lena sent a response to the Office of General Counsel on December 1st. 3 pages, surgical precision. She pointed out that navigable waters required a formal jurisdictional determination, which USDA had never issued. She noted that I had given permission for prior sampling, which negated any claim of adverse use. She attached documentation showing I'd paid property taxes on the disputed parcel since 1987, while USDA had paid 0, and she ended with a warning. Any further harassment of Mr. Whitaker, including but not limited to fines, liens, or disparagement, will result in counterclaims for intentional infliction of emotional distress, slander, and abuse of process. We await your substantive legal response. She also requested USDA's liability insurance information. The hate mail kept coming, but so did something else. December 5th, my trail camera caught a family in a minivan trying to sneak around the chain by driving through my hay field. They got stuck in the irrigation ditch. Spent 20 minutes rocking before giving up. December 7th, 2 teenagers tried to wade across the spillway with fishing poles. One slipped on algae and went in up to his waist. December 9th, a man in dress shoes attempted to climb the dam face to reach the water. He slid halfway down, ruined his slacks, and had to call his wife for a ride. I watched these videos with a cup of coffee, shaking my head. Entitled bureaucrats and their followers attempting agricultural navigation was not the retirement entertainment I'd expected. But I wasn't complaining. Every failed attempt was another timestamp in my evidence file. Another data point showing USDA knew they didn't have legal access and were trying to take it anyway. But Carla still had one card she hadn't played yet. And it was a card that could have worked if she hadn't gotten greedy. December 8th, 2024. I was checking cattle when the mail truck pulled up. The carrier handed me a certified letter from the county planning department. I signed for it, went inside, and opened it. Notice of violation. It has come to our attention that you have installed an unpermitted barrier across a public right-of-way on parcel 19-447B, Clear Creek watershed. This barrier must be removed within 10 business days, or you will face fines of $1,000 per day. The access road in question is designated as public right-of-way per the 1942 subdivision plat. Contact our office immediately to schedule removal. I read it 3 times. Then I pulled out my records. The 1942 plat showed nothing but open range, no roads, no subdivision, no development. Because in 1942, none of that existed yet. I built the service road in 1964 with my grandfather. I still had the receipts for the gravel. I called the planning department. This is Harlan Whitaker. I just received a violation notice about a road on my property. Can you tell me who filed the complaint? The clerk put me on hold for 2 minutes. Then, the complaint was filed by USDA on behalf of Clear Creek Watershed. It was flagged for priority review by Commissioner Roy Delgado. Roy Delgado, Carla's brother-in-law. Can you send me a copy of the 1942 plat you're referencing? It should be attached to the notice. It's not. Oh, well, I can email it to you. She did. I opened the file. The plat showed the watershed boundaries, utility easements, and a county road ending a half-mile east of my place. No access road to the pond because the pond wasn't part of any subdivision. It was surrounded by private parcels, including mine. I called Lena. They're lying. The county's claiming my road is public, but their own records show it's not. Who signed the violation notice? An inspector named Gerald Fouts, but it was flagged by Commissioner Delgado. Delgado, she repeated. Okay, let me make some calls. While Lena worked her end, I filed a Freedom of Information Act request with the county. I wanted every document related to my violation notice, every email, every memo, every communication between USDA and anyone in the planning department. FOIA requests take time, but I wasn't in a hurry. I had a court date coming up. Let them try to justify this in front of a judge. Then on December 12th, I got a call from a number I didn't recognize. Mr. Whitaker, this is Sam Ortiz. I'm a reporter with the Valley Dispatch. I cover local government and AG issues. I saw your name on some court filings and wanted to ask a few questions. I almost hung up, but something made me pause. What kind of questions? I've been investigating Commissioner Delgado for about 6 months. Ethics violations, conflicts of interest, that sort of thing. Your case popped up because Delgado personally expedited a violation notice against you in 48 hours. That's unusual. Mind if I ask what's going on? I gave him the short version. My property, the USDA's ramp project, the trespassing, the county violation. Sam was quiet for a moment. Then he said, Mr. Whitaker, can we meet in person? I think we can help each other. We met at a diner in the next town over. Sam was 42, wire-rimmed glasses, the kind of guy who looked like he'd been a journalist his whole life. He brought a folder 3 inches thick. "Okay," he said, spreading documents across the table. "Here's what I know about Roy Delgado. He's been county commissioner for 8 years. He's up for re-election this year, and he has a very interesting business arrangement with his brother-in-law." He slid a business registration across the table. Delgado Earthworks, LLC. Registered owner Luis Delgado, Roy Delgado's brother-in-law. They do a lot of federal work, watershed projects, drainage, maintenance contracts. And last year they started doing private work for USDA. I stared at the name. Delgado Earthworks, the company Carla hired for the ramp. Sam nodded. "Yeah, I pulled the bids for your watershed's access project. 3 companies submitted proposals. The other 2 came in at $148,000 and $162,000. Delgado Earthworks bid $212,000. They were awarded the contract anyway. That's a $50,000 difference." "Correct. And here's the fun part." He pulled out campaign finance records. "In the last 2 years, USDA employees and Watershed Council members have donated $14,000 to Roy Delgado's re-election campaign. Carla Mendoza personally gave $2,700, the legal maximum." I sat back. "So she donates to his campaign. He fast-tracks permits and violations for her. And his brother-in-law gets inflated contracts. That's what it looks like. But I need proof. I need documents, emails, something that shows coordination. Do you have anything?" I thought about my FOIA request. "I will in about 2 weeks." Sam published a preliminary article on December 15th. Headline: Watershed Equity or Federal Influence Peddling? It wasn't about me specifically. It was a broader piece about how USDA initiatives in the county were cozying up to local officials, donating to campaigns, and getting favorable treatment in return. But it mentioned Clear Creek Watershed by name. It mentioned Delgado Earthworks, and it mentioned an unnamed landowner fighting back against a federal agency that allegedly misrepresented jurisdiction over private ponds. The article got traction. Local AG forums picked it up. 52,000 views on a ranching subreddit. People started sharing their own stories in the comments. The local TV station called me for an interview. I almost said no, but then I thought about Carla's email blast calling me obstructive about the hate mail about the vandalism. Screw it. I said yes. The interview aired on December 18th. The reporter asked me point blank, "Is it true you're blocking 14,000 residents from accessing the pond?" "No," I said, looking directly at the camera. "I'm blocking a federal agency from building on my private property without permission. They've been trespassing for 7 months and calling it monitoring. There's a legal term for that. It's called theft. But families have been using that pond with your permission. Permission I can revoke at any time. That's what property rights mean. USDA says you're obstructive." USDA sold a $212,000 contract to the regional director's brother-in-law without competitive bidding. That's not obstruction. That's fraud. The clip went viral. 220,000 views in 3 days. The comments were overwhelmingly supportive. Good for him. Federal overreach is out of control. Why would anyone bid on federal work without checking the title? But in the watershed, the reaction was different. The USDA held another emergency meeting on December 20th. 3 council members resigned. One posted on the community app, "I was told this was routine. I didn't know we were trespassing. I'm out." That left Carla with a skeleton crew and a hemorrhaging budget. But she didn't back down. She doubled down. She hired a PR firm out of the city, sent glossy mailers to every landowner in the watershed. Don't let one obstructive rancher destroy our equity. She organized a Save Our Waters rally at the community center. 20 people showed up. Most of them looked confused. I watched from my porch through binoculars, shaking my head. Carla was on a microphone, voice crackling through a cheap speaker, talking about environmental justice and community values. But I could see it in the crowd's faces. They weren't buying it anymore, because the story had changed. It wasn't mean rancher blocks pond anymore. It was federal agency caught lying about jurisdiction. And once that narrative shifted, Carla couldn't spin it back. She made a critical mistake. She thought public opinion would destroy me. Instead, it was about to destroy her. Sam Ortiz published his full investigation on January 10, 2025. Headline: The Pond Access Land Grab. How one federal program built an empire on someone else's water. It was 3,500 words, meticulously sourced, and it tore the USDA program apart. The article detailed everything. My 1987 property purchase 31 years before the watershed plan even existed. The lack of any recorded jurisdictional determination on my pond. The USDA's marketing materials promising public fishing access without securing legal rights. The $212,000 ramp contract awarded to Commissioner Delgado's brother-in-law $50,000 over competitive bids. The campaign donations from Carla and other USDA staff. And the county violation notice expedited by Delgado based on a plat that didn't show the road in question. Sam included copies of documents, my survey, the watershed plan with its vague access language, the construction bids, the campaign finance reports. He even got a statement from the USDA Office of General Counsel, which boiled down to no comment. The comments section exploded. Over 1,200 comments in the first 2 days. This is why I'll never take federal cost share. Carla Mendoza should be fired. How is this not fraud? A Reddit thread titled "Justice for the Pond Guy" hit the front page of several AG subreddits. Someone made a meme of Carla's face photoshopped onto a pirate captioned, "But it's public water." It got 78,000 shares. Back in the watershed, the mood shifted hard. The community app went from pro-USDA to anti-USDA overnight. People started asking questions. Wait, we don't actually have legal access to the pond? Did Carla lie to us when we signed up for the program? Why did we pay a special assessment for a ramp we can't legally build? A petition started circulating demanding Carla's resignation and a full audit of the Watershed Council. Within a week, 412 landowners signed it, almost a third of the district. My mailbox, which had been full of hate mail a month ago, started getting apology letters. One couple wrote, "We're sorry we believed the agency. We didn't know the full story. Thank you for standing up for property rights." An older man stopped me at the feed store. "I voted for that assessment. I feel like an idiot. They lied to all of us." I didn't gloat. I just nodded and said, "Make sure you show up to the next council meeting." Then the County Ethics Board opened an investigation into Commissioner Delgado. The complaint cited Sam's article and requested a formal review of the campaign donations and the expedited violation notice. Delgado issued a statement denying any wrongdoing, but 2 weeks later he recused himself from all watershed-related matters. The violation notice against me was quietly rescinded. No explanation, just a one-sentence letter. Upon further review, the access road in question is determined to be private property. Case closed. I framed that letter and hung it in my office. But the real bombshell came from an unexpected source. A title insurance investigator named Yolanda Mercer. Yolanda worked for Consolidated Title, one of the largest title insurance companies in the state. Her job was to investigate irregularities, flag potential fraud, and make sure the company wasn't on the hook for bad claims. On January 15th, she sent a letter to the Clear Creek Watershed Council, CC'd to every landowner with a subject line that made my day. Title defect notice, public access claims. The letter was professional, clinical, and devastating. Yolanda had reviewed the title records for all 14,000 acres in the watershed. Her findings: 0 recorded USDA easements or jurisdictional determinations for public access on any parcel. The watershed plan mentioned public access in aspirational language, but contained no metes and bounds legal description, no recorded instrument, and no evidence of compensation paid to any property owner. Multiple landowners had been enrolled in USDA programs with marketing materials explicitly promising public fishing access as a program benefit, which constituted a materially misleading representation. Her conclusion: Consolidated Title cannot ensure any public access claim related to private ponds in Clear Creek watershed. Any such claim would be denied. In other words, if you enrolled in the program thinking you had public access, your title insurance won't cover it because the access never existed. And if you want to sue someone about it, sue the USDA. The fallout was immediate. 23 landowners, including 3 watershed council members, retained attorneys and threatened to sue the council personally for breach of fiduciary duty. The council's insurance carrier sent a denial letter stating that coverage for wrongful taking or conversion of non-council property was explicitly excluded under the policy, which meant the council's $280,000 in reserve funds were now exposed. The Office of General Counsel withdrew as counsel due to conflict of interest. Turns out representing a council that might get sued by its own members is a legal minefield. The council scrambled to hire a new attorney at $500 an hour. Then Carla made one last desperate play. She called an emergency landowner meeting on January 20th to propose a special assessment of $3,000 per parcel to fund the legal defense. $3,000 per parcel to fight me. The community center was packed, standing room only, and it did not go the way Carla expected. I didn't attend, but Ray Delgado recorded the whole thing on his phone and sent it to me later. Carla stood at the front, visibly shaken, trying to rally support. If we don't fight this, Harlan Whitaker wins. He'll control access to the pond forever. Our property values will. A man in the back stood up. You told us we had public access when we enrolled. We do have access. We just need to formalize. You lied. A woman shouted. You sold us a program with a benefit you didn't own. Another voice. Why should we pay $3,000 to fix your screw-up? This isn't my screw-up. This is. You're the project lead. You're the one who hired the contractor. You're the one who pushed this through without checking if we had the legal right. The meeting devolved into shouting. Carla tried to call for order. No one listened. Finally, 89 landowners signed a letter on the spot addressed to the council. We were misled about public access. We will not pay additional assessments to fund litigation. Settle with Mr. Whitaker immediately, or we will pursue legal action against the council. Carla's face went pale. One of her 2 remaining council members stood up and said, I resign effective immediately. The other followed. Me too. I'm not going down with this ship. Carla was left standing alone at the front of the room holding a gavel with no counsel and no support. 3 days later, Lena received a call from the council's new attorney, a guy named Peter Drummond. Miss Torres, my client is interested in discussing settlement. I'm listening. The council is prepared to acknowledge that no jurisdiction exists, record a notice on all property records to that effect, and issue a public apology. They're also willing to discuss reasonable compensation. How reasonable? $75,000. Lena laughed. Mr. Drummond, your client trespassed on my client's property for 7 months, attempted to build a $212,000 structure without permission, slandered him in writing to 14,000 people, and subjected him to harassment and vandalism. $75,000 doesn't cover his attorney fees. What's your number? $180,000 plus all the terms you mentioned, plus Carla Mendoza's resignation. I'll discuss it with what's left of the council. 2 days later, they agreed to everything except Carla's resignation. She quit on her own the next morning, January 25th. The hearing I'd been building toward since October arrived on February 1st. The county courthouse was a limestone building with marble floors, the kind of place that made you feel like the law still meant something. I arrived at 8:30 for a 9 o'clock hearing. The courtroom was already filling up. I counted at least 60 people in the gallery. Most of them were watershed landowners. Some looked curious, some looked angry. Sam Ortiz was in the press section with a notepad. Ray gave me a small nod from the back row. Lena met me outside the courtroom doors. She was wearing a navy suit and carrying a leather briefcase that looked like it had seen a few wars. You ready? She asked. I've been ready since October. Good. Remember, let me do the talking. If the judge asks you a direct question, answer it calmly and stick to facts. Don't editorialize. Got it. And Lena, we're going to win this. Textbook win, she said quietly. Judge Harold Kemp took the bench at 9:03. He was in his late 60s, silver hair, reading glasses on a chain. He had a reputation for no-nonsense rulings and zero patience for agency overreach. "Good morning," he said, settling into his chair. "This is a preliminary injunction hearing on the motion filed by Harlan Whitaker and the USDA's counterclaims. Let's get started. Counsel, state your appearances." Lena stood. "Lena Torres for petitioner Harlan Whitaker, Your Honor." On the other side, a woman in her 40s stood. "Melissa Dryden for respondent Clear Creek Watershed Council and USDA, Your Honor." "Miss Dryden, you're up first. Tell me why the court should deny Mr. Whitaker's injunction." Melissa Dryden was polished, confident, and clearly expensive. She approached the podium with a folder full of notes. "Thank you, Your Honor. The council's position is straightforward. For 7 months, the USDA has conducted water quality monitoring on the pond now owned by Mr. Whitaker. This access was open, continuous, and with the permission of Mr. Whitaker. Families have fished there, held educational events there, and relied on that access as a fundamental program benefit. To now suddenly block access harms 14,000 watershed residents and undermines the reasonable expectations upon which they enrolled in the program." She clicked a remote, and photos appeared on the courtroom screen. Families on the bank, kids with fishing poles, USDA staff in vests. "These are not trespassers, Your Honor. These are program participants exercising what they reasonably believe to be a public right." She played a video, kids laughing. A little boy, maybe 8, saying, "Why can't we go fishing anymore?" A mom with her hand on his shoulder looking into the camera. "Our kids don't understand. This has always been part of our watershed program." Melissa sat down. "It was a good performance. Emotional, sympathetic, designed to make me look like the Grinch who stole fishing." Judge Kemp made a note. Then he looked at Lena. "Miss Torres." Lena stood, walked to the podium, and didn't open a single piece of paper. "Your Honor, this case is not complicated. It's Property Law 101. Mr. Whitaker owns the land. The USDA does not. There is no jurisdictional determination, no easement recorded or otherwise. Everything else is noise." She clicked her own remote. My 1998 survey appeared on the screen, clean and official, with a surveyor's seal in the corner. "This is the certified survey of Mr. Whitaker's property conducted in 1998 when he purchased it. The boundary clearly includes the pond and the access road. This property was purchased 31 years before the watershed program was even created." Next slide. My deed with the legal description highlighted. This is the recorded deed. It has been on file with the county since 1987. No easements, no encumbrances, clear title. Next slide. Property tax records. Mr. Whitaker has paid 100% of the property taxes on this parcel for 37 years. The USDA has paid 0 because it's not their property. Judge Kemp leaned forward slightly. Miss Dryden raised the issue of waters of the United States. What's your response? 2 responses, Your Honor. First, the Clean Water Act requires a formal jurisdictional determination before asserting federal control over a private water body. The USDA has never issued one for this pond. And second, even if they had, isolated farm ponds are explicitly exempt under the 2023 Supreme Court ruling in Sackett v. EPA. This pond has no direct surface connection to a navigable water. It's spring-fed and entirely on private land. The judge nodded slowly. Continue. Lena pulled up another document. This is the 2018 Watershed Management Plan. Page 22, Section 4 mentions public access. But there's no legal description, no metes and bounds, no recorded easement, just vague aspirational language. And here, she highlighted a sentence. Section 9, subsection B states, access to non-program properties requires written consent of the affected landowner. Their own plan requires my client's permission. She let that hang in the air. Then she played her own video. Trail camera footage timestamped. Carla and 2 people with bolt cutters trying to cut the lock. Audio. Just cut it. He can't stop the federal government. Melissa Dryden's face went white. Lena didn't even look at her. Your Honor, This was recorded 3 hours after Mr. Whitaker lawfully installed a lock on his private property. The USDA project lead knowingly and willfully attempted to destroy that lock to gain unauthorized access. That is not the behavior of someone who believes they have a legal right. That's the behavior of someone who knows they're trespassing and doesn't care. She clicked to the next slide. An email from Carla Mendoza to the regional director dated March 2024. Subject: Access issue. Body: Need to secure Whitaker Pond before he realizes no JD. Lena looked up at the judge. They knew, Your Honor. They knew they didn't have jurisdiction and they proceeded anyway. Judge Kemp turned to Melissa. Counselor, did you know about this email? Melissa stood slowly. I was not aware of that specific communication, Your Honor. So your client didn't disclose it. We're still in discovery. This email is dated 10 months ago. It's directly relevant to your jurisdiction argument. If they knew they didn't have a JD, the access couldn't have been in good faith. Melissa had no response. The judge turned back to Lena. Anything else? One more thing, Your Honor. Lena approached the bench and handed a document to the clerk. This is an affidavit from the prior property owner, located and interviewed by our office. He states, and I quote, I allowed occasional sampling as a courtesy to the USDA. I made it clear that this was not a permanent arrangement and did not convey any property rights. When I sold the property in 2020, I informed the buyer that no access rights existed. She stepped back. Your Honor, Mr. Whitaker is not the villain here. He's a retired soil conservationist who bought land, paid for it, improved it, and has been subjected to months of harassment for asserting his legal rights. The USDA sold a program promising benefits they didn't own. That's not Mr. Whitaker's fault. That's fraud. And it's not this court's job to fix the USDA's fraud by taking my client's property. Judge Kemp removed his glasses and rubbed his eyes. Then he looked at Melissa. Miss Dryden, I've reviewed the filings. I've heard your arguments. Do you have any legal basis, any case law, any statute, anything that supports asserting federal jurisdiction under these facts? Melissa stood. Your Honor, we believe that the public trust doesn't override property law. We would argue that the reliance interest of 14,000 residents, that's a policy argument, not a legal one. Do you have a legal basis? Melissa hesitated. Not at this time, Your Honor. Then we're done here. Judge Kemp put his glasses back on and looked at his notes. Then he looked up. Mr. Whitaker owns the property. That's not in dispute. There is no jurisdictional determination. That's not in dispute. The USDA has not met the requirements for federal control, both because of the lack of a JD and because the pond is exempt under SACIT. The evidence shows that the USDA knew it lacked legal access and proceeded with construction plans anyway, culminating in attempted destruction of Mr. Whitaker's property. This is one of the clearer property disputes I've seen. He picked up his gavel. I'm granting Mr. Whitaker's motion for preliminary injunction. The Clear Creek Watershed Council and USDA, its agents, and all program participants are permanently enjoined from entering Mr. Whitaker's property without his express written consent. Any violation of this order will be considered contempt of court. Further, I'm awarding Mr. Whitaker attorney fees and costs in the amount of, he glanced at a document, $42,000, payable within 30 days. If the USDA wishes to pursue access through negotiation or condemnation, they're free to do so. But based on this record, I don't see a path forward. We're adjourned. The gavel came down. One sharp crack. Carla, sitting in the front row, put her face in her hands. Several landowners in the gallery started whispering. A few got up and left immediately. Ray was grinning from the back row. Sam was scribbling notes furiously. Lena shook my hand. Textbook win, she said quietly. As we walked out, an older woman approached me in the hallway. Mr. Whitaker, I owe you an apology. I signed that petition against you back in November. I didn't know the whole story. Thank you for standing up for what's right. I nodded. Thank you for saying that. 2 other people stopped me on the courthouse steps to apologize. One man said, Carla lied to all of us. I'm glad you won. I didn't gloat. I didn't celebrate. I just got in my truck and drove home. Because winning in court was only half the battle. The real question was, what do you do with power once you've got it? Carla Mendoza resigned as project lead on February 3rd. No ceremony, no farewell email, just a one-sentence announcement to the watershed list. Effective immediately, I am stepping down from the council. The special election happened 2 weeks later. Ray Delgado ran unopposed and won. His first act as chairman was to settle my lawsuit, $180,000. A public apology posted on the watershed website and mailed to every landowner. And a recorded notice on all 14,000 property records stating clearly, no public access easement or USDA jurisdiction exists for the Whitaker Pond. Commissioner Roy Delgado was censured by the County Ethics Board in March. He didn't run for re-election. His brother-in-law's company, Delgado Earthworks, was quietly removed from the USDA's approved contractor list. The Office of General Counsel received a reprimand from the regional director for failure to adequately investigate claims before asserting federal jurisdiction. It didn't hurt them much, but it was something. I could have walked away at that point, taken the money, kept the chain locked, and lived out my retirement in peace. And for a few weeks, I considered it. But then I started thinking about what Lena had said back in October. When you win, what are you going to do with it? So I drafted something I called the Clear Creek Conservation License. It wasn't an easement. It was a revocable license, meaning I kept full control and could terminate at any time if people didn't follow the rules. The terms were simple. Maximum 25 families per day, managed through an online reservation system. Access hours 6 a.m. to 8 p.m., May 1st through September 30th. No motors, no structures, no fires, no alcohol. Pack in, pack out, leave no trace. Every family had to complete 1 hour of volunteer pond cleanup per season. $30 annual maintenance fee per household, which covered gravel road upkeep, a portable toilet, and liability insurance. The license was revocable if anyone violated the rules. 1 strike, you're out for the season. 2 strikes, you're banned permanently. I presented it to Ray and the new council in April. They read it, looked at each other, and Ray said, "This is more than fair, Harlan. Thank you. I never wanted to block access. I told them I wanted respect. Now we have both." But I didn't stop there. The $180,000 settlement was more money than I needed, so I put it to work. First, I established the Clear Creek Watershed Trust with $100,000. It was a small nonprofit registered with the state, focused on protecting the pond and surrounding riparian area from future overreach. We partnered with the State Department of Wildlife to install fish habitat structures, plant native willows along the shoreline, and conduct quarterly water quality testing. The goal was to make sure that ponds stayed pristine for the next 100 years. Second, I endowed a $50,000 scholarship called the Soil Steward Scholarship, $2, $500 annually to a local high school student pursuing soil science, range management, or a related field. The first recipient was Ray's niece, Sophia Delgado, who was headed to State University in the fall to study agronomy. When I handed her the check at the awards ceremony, she teared up. "Thank you, Mr. Whitaker. This means everything." I shook her hand. "Your uncle stood up when it mattered. This is for both of you." Third, I set aside $30,000 for something I called the Good Farmer Legal Defense Fund. It provided free 30-minute consultations with Lena for any landowner in the county dealing with federal or local overreach. Not just watershed issues, anyone. Because I'd learned that Carla wasn't unique. There were a dozen Carlas in a dozen agencies, all leveraging authority they didn't legally have, hoping no one would push back. Now someone could. On May 15th, we held the first annual Pond Restoration Day. 140 volunteers showed up. We planted 60 native trees, installed 20 wood duck boxes, cleaned 3 tons of trash and debris from the shoreline, and built a small nature trail on the far side of the pond. Families I'd fought with in court were working side by side with me, hauling mulch and planting shrubs. Even some of the people who'd sent me hate mail showed up to apologize in person. One guy, mid-40s, pulled me aside. "I wrote some awful things about you online. I'm sorry. I should have listened to your side." Water under the dam, I said literally. He laughed. We kept working. By the end of the day, my back was sore. My hands were covered in dirt, and I felt better than I had in months. Sam Ortiz wrote a follow-up article in June. Headline: How One Rancher Turned Federal Overreach into a Conservation Legacy. It got syndicated to 3 regional papers. I started getting emails from landowners all over the state dealing with similar disputes. I couldn't help all of them, but I answered every email, gave advice, shared templates, pointed them toward resources. Some of them won, some settled, a few lost, but at least they fought. That mattered. In September, I was invited to speak at the State Property Rights Conference. I stood in front of 300 people and told them the same thing I'll tell you now. Document everything. Document every conversation, every email, every incident. Paper trails win cases. Know your boundaries. Get a survey. Understand what you own. The law protects you, but only if you're willing to use it. Authority without accountability is just bullying. Make them accountable. When you win, don't just win for yourself. Build something that lasts. Build something that helps people. That's how you change the culture. It's been a year since I locked that chain across the service road. The conservation license is working. 212 families used the pond last summer. 0 rule violations. The trust secured a matching grant from the state, another $150,000, which we're using to build an accessible fishing platform for people with disabilities. Ray's Council is working with me to develop a trail system around the watershed on properties whose owners actually consent. This time with recorded agreements. Carla moved to a different region about 200 miles away. I heard she took a job with a different agency. I don't wish her ill. I just hope she learned something. As for me, I'm still here. Still drinking coffee on my porch at sunrise. Still watching the water. Still grateful I stood my ground when it mattered. If you're fighting USDA, EPA, or any agency that thinks jurisdiction is a suggestion, know this: you're not alone. Share your story. Learn from others. And if this story helped you in any way, share it. Justice is contagious. Now go protect what's yours.